Corpbiz.
Hello everyone, a very warm welcome to you all. This is Monisha with you from Corpbiz, and in this video we are going to talk about the trust registration process in India. Let's take an overview of the trust registration. Trust registration is a process of legalizing the trust deed, a legal contract between the settlor and the trustee, from the registrar of the respective jurisdiction. The trust serves as a legal medium liable for the lawful distribution of the settlor's asset among the concerned beneficiaries. The trust comes to an effect as soon as the registrar provides its authorization in the trust deed. So, what is trust in an Indian context? The Indian Trust Act 1882 governs all the registered trusts in India and facilitates the legal provisions for the same. The trust is usually referred to as a legal arrangement where the trust's owner transfers the property to the concerned trustee, aka beneficiary. The object of trust is to ensure the seamless transfer of the truster's assets among the beneficiaries as per the clauses cited in the trust deed. A trustee selected by the grantor is liable for administering the trust and finally distributing his or her asset to the designated beneficiaries selected by the grantor when the trust is set up. Higher, family members or charity are some common beneficiaries of the trust in India. Trust can also be utilized to reduce taxes, simplify or avert the probate process and safeguard assets. There are various types of trust in India such as revocable, testamentary, irrevocable, charitable trust, asset protection trust, spendthrift, special needs trusts. Now let's take a look on what are the benefits of trust registration. To involve in charitable understanding, a charitable trust is primarily a way to set up your asset to benefit you, concerned beneficiaries and a charity simultaneously. Such trust could render various advantages for a person seeking to aid society with non-essential assets such as stock or real estate. Accessibility to tax exemptions. All registered trusts in India have access to several tax exemptions offered by the Income Tax Department. Since the object of the trust doesn't revolve around profit generation like NGO, they are eligible to avail various tax relaxations. However, such a benefit is only available to trusts that have a registered deed at their disposal. Trusts are very useful in ensuring taxation relaxation on capital and income. The trust may facilitate better coverage for the settlor, the beneficiaries, and the trust assets from stringent tax provisions. Provides benefits to financially aggrieved individual. The registered trust facilitates the much needed financial to the poor people and the masses via charitable activities. Encounters minimal legal hindrances. The Indian Trust Act 1882 ensures comprehensive legal protection for the trust. It also prevents any third party to make an unnecessary claim that could endanger the legal standing of the trust. It ensures legal coverage for the family wealth. Trust can be used to allocate specific assets such as land and interest in any entity formed by the family, which otherwise would not be practical for a truster to split between individuals. It averts probate court. Anybody can leverage trust registration as a tool for transferring an asset to the heir in the absence of a will, as the legal title of the assets transfers from the settlor to the trustee in case when they are settled, there is no change of ownership after settlor's demise, thus evading the requirement for probate of a will on account of a trust's assets. Unlike probate, the trust acts as a private agreement that skips the requirement for additional registration. The use of a trust can also avert the economic adversity often encountered by surviving spouse even as waiting for the grant of probate. Emigration of family. When an individual and his or her family move to another nation, it is a perfect event to establish a trust to get rid of taxation in the destination country, thereby safeguarding the family assets and facilitating flexibility in its organization. So what are the different types of trust? Let's explain in detail. There are three types of trust in India: public trust, private trust, public-cum-private trust. While private trust function as per the provision of Indian Trust Act 1882, public trusts are categorized into religious and charitable trust. The Religious Endowment Act 1863, Charitable and Religious Trust Act 1920, the Bombay Public Trust Act 1950 are some of the prominent statutes for enforcement of public trust in India. Private trust. Private trust refer to a legal arrangement created for the benefit of individuals other than a public or charitable purpose. It is formed for the financial benefit of one or more beneficiaries who are known to the trustor. Private trust doesn't serve a charitable purpose and its benefits are only accessible to designated beneficiaries. Such trusts are bound to follow the provisions of Indian Trust Act 1882. Public trust. A public trust essentially benefits the public at large. Unlike private trust, public trusts do not function under the Indian Trust Act and are formed to serve a charitable or religious purpose. Such trust follows the general law, which is in effect for the time being. Just like the private trust, these trusts may be formed inter vivos by will. Now coming to public-cum-private trust. As the name suggests, the public-cum-private trusts serve a dual purpose. They are eligible to use their income for the public as well as private purposes. That implies that beneficiaries of such trust could be either public or private persons or both. So let's discuss the fundamental documentation required for trust registration in India. So the documents that one needs to arrange for trust registration includes proof related to identity for trustor and trustee such as Aadhaar card, voter ID, passport, DL, etc. Address proof related to registered office such as copy of certificate of property, utility bills, no objection certification from the landlord if the property is rented, trust deeds objectives, details about the trustee and settlor such as self-attested copy ID and address proof and occupation, trust deed on proper stamped value, trustee and settlor photos, trustee and settlor PAN details. Trust deeds must reflect the following information also, like number of trustees, trust registered address, proposed name of the trust, proposed rules that will govern the trust, presence of a settlor as well as 2 witnesses at the time of registration of trust. Now let's discuss the step-by-step procedure for registering a trust in India. The detailed procedure for trust registration entails the steps such as step 1 includes selecting an appropriate name for the trust. The first and foremost step in the process of trust registration is the name selection for the proposed trust. Be mindful when serving such a purpose and take the following points into account to avoid any hassles, like the name should fit the provisions of the Emblems and Name Act 1950. There should be no violation whatsoever when it comes to Trademark Act. The name should stay to the originality. Now step 2 of the process of registration of trust includes drafting of trust deed. So drafting of trust deed is an important undertaking because it is the only thing that makes the trust legally enforceable. In general, the trust deed consolidates the below mentioned clauses like object clause. The object clause reflects the object behind the formation of the trust. Acceptance of funds. This clause enables the trust to accept contributions, donations and subscription from any person, government body or charitable avenue in the form of cash, immovable asset without any charge on it. Furthermore, the clause states that any contributions that hampers the trust object are non-acceptable in nature. Now comes the investments. The investment clause sets out the condition for the lawful and effective administration of the trust funds. Further, this clause also framed condition for effective allocation of the additional funds that are not in use and could help in generating extra income via investment. Let's discuss some of the powers of the trustees. As the name suggests, this specific clause talks about the responsibilities of the trustees. Generally, such clauses confer the following powers to the trustee, like appointing employee or employees, alienating the trust properties, opening the bank account in the name of the trust, suing defaulters in case of legal dispute on behalf of the trust, accepting any gift, donation via legitimate individuals or sources, investing additional funding in securities account and audit. This clause mandates the trustees to administer the book of accounts on a regular basis. Further, it also sets out the requirement for account auditing that should be conducted by the certified chartered accountant. When we are discussing the registration of the trust, we need to know about the winding up procedure for trust as well. A trust is wound up when all of the trust properties or assets are lawfully distributed to the beneficiaries or to a similar entity, either directly or through resettlement. The involved parties must identify any tax obligation incurred owing to the transfer of assets when the trust is wound up. Furthermore, this clause renders the requirement of conducting such legal undertaking with the approval of charity commissioner, court, any other law to mitigate any chances of legal dispute. So, what are the penalties for violating the compliance of trust registration? Civil and criminal penalties includes the violation of the provisions of trust deed incurs both civil and criminal penalties for the defaulters. Section 405 to Section 409 of the IPC 8060 sets out the provisions related to criminal breach of trust. Application for tax deduction account number. The trust or institution ought to make the official request before the assessing officer for the allotment of tax deduction account number soon after being registered. For this purpose, trust can use the Form 49B facilitated by Income Tax Department. The tax deduction account number should be quoted on all the challans for the payment of sum under Section 200 and TDS certificate, as well as returns delivered under Section 206, 206A and 206B. Section 272, subsection B, Clause B talks about the penalty to be levied on the trust failing to avail the tax deduction account number. The said section slaps the penalty of 10,000 rupees in aforesaid events. Failure to furnish the return of income. Failure to facilitate the return of income attracts significant penalties under the Act. The return of income shall not stand invalid if the TDS certificate has not been provided along with the return of income owing to the default of the taxpayer is not rendering such certificate. The taxpayers are mandated to produce this certificate within 2 years from the end of the assessment year. So, what is the role of Section 12, subsection A, Clause B on the registered trust? Ensuring continual exemption under Section 10 or 100, all the active existing charitable trusts or institutions are mandatorily required to secure the new registration under Section 12A(b). Additionally, the trust registered under Section 10, 23C or Section 12AA shall renew their registration under Section 12AB. The last date by which application for registration and permission is required to be made. So why you should approach Corpbiz for obtaining trust registration? Our Corpbiz experts will be at your service for facilitating required support concerning trust registration and its compliance. The trust registration in India revolves around sensitive and error-prone legal implication. This is where our expertise come into so handy. Our professionals make sure that you have more clarity on the governing provisions of trust in India so that you can undertake trust-related activities with minimal legal hassles. How can Corpbiz help? Governing compliances and registration legalities could run any client into troubles of application rejection and refiling, which indeed is a time-consuming and cumbersome task. However, all such nuisances can be overcome if you opt to proceed via Corpbiz way. Our first step is screening of client's requirement regarding trust registration setup in India. Second step includes name selection for the trust in view of prevailing bylaws. Third step is about identification of applicable provisions and legalities. The fourth step is of insertion of relevant clauses in the trust deed depending upon the nature of trust. Step 5 is about availing necessary authorization from the sub-registrar. So this was all about the trust registration process in India. For more concerns or questions on working of the trust in India, kindly email us at info@corpbizadvisors.com or call on the numbers mentioned over the screen. Do like, share and subscribe. Thank you.